Good evening, everyone. I'm Colleen Feige, the president of the League of Women Voters, Edina, and it's my pleasure to welcome you tonight to hear about the Supreme Court. Is it still the least dangerous branch, as they thought decades ago? We are tonight very happy to have Professor Tim Johnson from the University of Minnesota. He is the distinguished professor, the Horace Morse Distinguished Professor for Political Science and Law. So he's done a lot of research. He knows more about the Supreme Court than many, many people in our country, and he has been in many different journals, political and law, and on television many, many times. So I think you're going to learn a lot from him tonight. As you may have noticed when you sat down or came in, we gave you cards. That would be for your questions. And we'll save the questions until the end of the presentation, and then we'll give them to him. Kathy Sella is our moderator for the evening, and thank you, Kathy, for your time. And I think with that, we'll turn it over to you, Professor Johnson. Thank you.
Thank you. I appreciate it.
Yes, we will pick up the cards. If you have your questions ready, you can just raise your hand. We can give you another card, but we'll save the questions until the end of the presentation. Thank you.
Thank you very much. I appreciate it, and thank you all for coming out tonight. I know this is your first meeting in person since the pandemic began, and I'm really honored to be at the League of Women Voters to be your first speaker in this time. I know the important work that you all do for voting and voting rights, and it's appreciated by everybody, I think, in this country, and by political scientists in particular. So thank you very much. So yeah, I'm here to talk about the Supreme Court tonight, and obviously the court has become an incredibly controversial topic, incredibly polarized, incredibly ideological, and so it is good to step back and ask a question like this, because at least if you are on one side of the aisle in 2022, you would argue that there is no way that we could argue that the court is not dangerous at all, because it is incredibly powerful. And so the argument that I'm going to make tonight is that that has probably always been true, that the court, despite the power that Congress has in Article 1 and the abilities that the president has laid out in Article 2, that the court in some ways can be seen, given oftentimes, and in particular again in 2022, the gridlock that we face in those two elected branches of government, that the court holds a whole lot of power. And so this debate begins, as I said, at the founding, and it begins between two highly partisan Federalists, in fact, right? This was not actually a cross-party debate, it was an in-party debate. And it was a debate between Alexander Hamilton and John Marshall. And while they weren't standing up debating one another like in a Lincoln-Douglas debate or in a presidential debate, the theories that they laid out about the Supreme Court and its role in our democratic republic is one that really continues to resonate today. And so I'll lay out the argument historically and then lay out how I will make my case in terms of the court being such a powerful branch of government. But let me consider first Hamilton's argument. And Hamilton makes the argument, in fact, and it's one that we would have all learned in civics, and in particular, if you're interested in the Federalist Papers, it's one of the Federalist Papers that is often assigned. We don't assign every Federalist paper for our students to read. I think they would revolt, but Federalist 78 is one of the key Federalist Papers, and the upshot of what Hamilton has to say is that, in fact, the judiciary isn't very strong. It's weak because it doesn't hold the sword or the purse strings. It cannot declare war. It cannot or does not have the power to enforce decisions it makes, and it can't spend money or, in fact, bring money in. And in Hamilton's view, that suggests that it has neither force or will, and as his quote ends, all it has is judgment, that the court can simply say something, but it's unclear whether what it says can ever be enforced in any way, shape, or form. On the other hand, the fourth Chief Justice of the United States, John Marshall, lays out a pretty different view of the United States Supreme Court and its role in our democracy. And in the famous or infamous, depending on your point of view, Marbury versus Madison, Marshall says, straight up, we are powerful. Whether you like it or not, we are. And the direct quote is, it is emphatically the province and duty of the judicial department to say what the law is. Now, that's the power of judicial review. And the words judicial review do not appear in the Constitution. And it is still debated even today whether or not the court has or should have that power. But Marshall created that power, and I'll say more about that in just a little while. But let me go back to Hamilton and make the case for Hamilton that, in fact, the institution was a weak one. Early in the court's history, you could imagine that Hamilton was correct. It decided very few cases. In the first decade of the court's existence, beginning in 1791, it decided 20 cases total. At its height in the late 1800s and into the 1900s, the court was deciding over 200 cases per term. But it was deciding an average of 2 cases per term during its first decade in existence. And in fact, in its first 18 months of existence, it decided exactly 0 cases. And nobody wanted to serve on the court because it was considered so weak. John Jay, the first Chief Justice, accepted work in another branch of government while he was Chief Justice. He, in fact, became an ambassador, which is absolutely positively a violation of the separation of powers, but this happened on a regular basis. John Marshall himself was Secretary of State while he was still Chief Justice of the United States. Alexander Hamilton was asked by George Washington to replace John Jay when John Jay, because it wasn't enough to be an ambassador and Chief Justice, because the court was so weak, Jay resigned to run, not become, but run for the governorship of New York. So when he leaves, Washington says to Alexander Hamilton, why don't you become the Chief Justice? I'd like to nominate you. And Hamilton says, no, I have too much to do in New York. And he cited, quote, his anxiety to renew his law practice and political activities in New York City. John Rutledge, at the same time, or contemporarily to this, quits the Supreme Court, not because he was sick or wanted to spend more time with his family, but because he wanted to become the Chief Justice of the South Carolina Court of Common Pleas. Imagine that today, John Roberts resigning so that he could become Chief Justice of South Carolina. That's not something that we would assume would happen today, but the court was considered so weak that they were just fleeing the court in droves in some sense. In other words, Hamilton's prediction that the court would not have a lot of power seems to be right. No one wants to serve on the court. And then, of course, you have the case of the court not holding the sword. And there is the mythological argument between Marshall and President Andrew Jackson about the Trail of Tears. When the Supreme Court rules in Worcester versus Georgia in 1832 that you cannot take a group of Native Americans from Georgia and march them across to Oklahoma and give them the worst land in all of the United States. And the famous mythological quote by Andrew Jackson is, John Marshall has made his decision, now let him enforce it. Because you can't imagine 9 old white guys in black robes with no guns going to stop Andrew Jackson's army from doing what they did to the Native Americans in Georgia. The part of the Jackson debate that is true is, in fact, a letter that Jackson wrote to John Coffey. And he did directly say, the decision of the Supreme Court is fell stillborn, and they find that they cannot coerce Georgia to yield to its mandate. John Marshall is impotent. And the president was right. So people don't want to be on the court has no power. It's possible that Hamilton is correct. But there is a case for John Marshall. Things change when President Adams nominates the quintessential and, in fact, the final Federalist to exist in our governmental structure, John Marshall. And he did so after losing the election of 1800. Adams was a lame duck president, but he knew that the only way to preserve some power for the Federalists was to, in fact, pack the court system. So all sorts of new judgeships were created in the lower courts, and Adams was savvy enough to pick John Marshall to become chief. Marshall becomes Chief Justice. I've already talked about Marbury versus Madison. He creates the power of judicial review out of whole cloth and says, this new institution that you all think is so weak is now going to be strong because we're going to tell you what is constitutional and what is not. But he did other things as well that were highly controversial at the time, despite the fact that there was no social media to spread that controversy, at least as quickly as the newspapers and other pamphlets did back in the day. So Marshall lays down the law and upholds federal judicial power over state courts in Cohen's versus Virginia and Martin versus Hunter's lessee. He makes clear that the federal government, that is Congress in particular, under Article 1, Section 3, has absolute power over interstate commerce in McCulloch versus Maryland. The state of Maryland tried to tell the federal government that it could not create the First National Bank of the United States. And John Marshall says very clearly, we can absolutely, or the federal government can absolutely do that. That is under Congress's power. At least you assume it's under Congress's power with its power to tax and spend. And then finally, and let me go back to that now. And then finally, one other point about interstate commerce. The court expands the power over interstate commerce even wider in Gibbons versus Ogden. Now, you may ask yourself, why do I keep saying that it is John Marshall that did this? Because the Supreme Court is not made up of one person. John Marshall ruled the U.S. Supreme Court with an iron fist. What he said went. What he wanted was what the court did. And the decisions he believed should be handed down were ultimately handed down. Now, how did he make that happen? How did he take a court that didn't actually have 9 justices, it had 6 justices at the time? Not sure what the framers were thinking or what Congress was thinking when it passed the Judiciary Act of 1789 and said it makes sense to have an even number of justices instead of odd, but we begin with only 6 justices: Marshall, Patterson, Chase, Washington, Moore, and Cushing. How did Marshall make the court powerful beyond those rulings that I talked about very quickly a minute or so ago? Consider what he accomplished in 34 years on the bench. The Marshall Court ended up issuing, after not doing a whole lot in its first couple of terms, over 1,000 opinions between 1801 and when Marshall died in 1835. Marshall wrote more than half of them himself, and almost all of them were unanimous, because he refused to let the court hand down decisions where there were dissents. He wanted the court to speak with one voice as a court. Now, one of the ways he probably assuaged his colleagues to sign on to almost every one of his opinions is that most of those opinions were written in pubs or other bars. Okay? The justices at the time did not live in Washington, D.C. They lived in their home states back in the circuits where they also served as lower court judges. So when they would come together for the court's term, they stayed together in the same boarding houses. That would be on the second floor, and they would go to the pub down below and drink either mead or beer and take their meals together. And it's pretty easy to be collegial when you're imbibing beer with your colleagues and figure out how to make compromises and write one opinion that everybody agrees with. So Marshall lays the foundation. He lays the foundation for the court's role as the ultimate interpreter of the Constitution, and he paves the way in the end for the expansion of federal government power in the 19th, 20th, and certainly today in the 21st century. And so my argument for the remainder of my talk is that the court has been, and I will pull back a little bit, mostly the most powerful branch of government, despite not being able to pass or enforce laws or control the budget in the United States. To make this claim, I'm going to focus on 4 eras beyond the Marshall Court. And I'm going to end with the current court and argue, ultimately, that with Congress and the White House melting down, and often in gridlock, that the court's power is quite extraordinary. So who am I going to deal with, and how am I going to deal with them? I'm going to deal with the court's power during the New Deal era, both before and after the switch in time in 1937 in West Coast Hotel, or West Coast Hotel, and I'll talk more about that in a couple of minutes. So I'll talk about the New Deal era prior to 37 and then the post-New Deal era where the court is powerful in both respects, even though there's a massive change and overturn in the number of, in which justices are on the bench at the time. And then, of course, I'll talk about the mighty Warren Court. I'll skip the Berger Court and the Rehnquist Court, although one could make the same argument possibly in some areas of the law for them, but I will finish with the Roberts Court era. So let me actually turn first to the pre-1937 version of the New Deal court. The court was incredibly powerful prior to the 36 election, and possibly even more powerful than you could imagine until its ultimate showdown with FDR on March 9th, 1937, which is the date that he gave his infamous fireside chat on federal court expansion, or as we have come to know today, the court packing plan, which was wildly unpopular even among Democrats at the time. But let me talk about this early court, and by early court I mean that pre-1936 election, and in the end, that pre-1937 fireside chat court. The court was controlled, and the pointer will not probably allow me, but I'll point out for you the four justices who are on the far right who are sort of faded out, and that's because in the case from which I took this image, they were in dissent. The court was controlled by those four who were known as the four horsemen of the apocalypse: Justices Sutherland, Vandevenner, McReynolds, and Butler. They also had on their side Justice Owen Roberts, who provided up through 1937 in West Coast Hotel versus Parrish. Prior to that time, the fifth vote to kill almost every single one of FDR and the Congressional Democrats' New Deal plans to help save the economy after the Great Depression. So what did they do? What were they striking down? They were striking down, as I said, every single time FDR got an economic plan passed, it was being stricken as unconstitutional by the court, and FDR couldn't stop them. So, for instance, the severe limitations on federal power, and these concern, and it's why I talked about interstate commerce, even ever so slightly with the Marshall Court. Marshall made very clear that there was absolute power of Congress to control interstate commerce, that is the exchange of goods across state lines. And this court, prior to 1937, takes away that power to a great degree. So, let me be clear, in 1935, in a case called Carter versus Carter Coal Company, the Supreme Court says production of a good before it moves across state lines is not part of interstate commerce. It is production in a state, and because the production happens only in one state, the federal government needs to keep its hands off of production. Well, the federal government had not only to help the economy, but also to put some regulations on how long we could let 10-year-old kids work down in coal mines. The four horsemen and Owen Roberts say you can't regulate that. If the kids' parents want to make a contract with the coal company and keep them down 18 hours a day in the mines, they can certainly do that. So the federal government can no longer control production in any way, shape, or form. And as an aside, this court also said the state governments couldn't do so either, even under state police power. At the same time, this court, with the four horsemen, says once a product reaches its destination, the federal government also cannot regulate at all. The famous case in 1935, the same year as Carter and Carter Coal Company, is Schechter Poultry Company versus the United States. Schechter is a very, very difficult case because it essentially says, although in some sense it's very easy, you've been moving poultry. That poultry might be problematic. It might be making people sick if it's not regulated properly. But now that it's reached its destination, federal government has no power. So now you've got, when you're making something, the federal government has no power. When you get something to its destination so it can be sold, the federal government has no power. So where does the power reside? Only when those goods are being actually transported, which is essentially no power at all. I mean, certainly the federal government can regulate the railroads or the boats on which these goods are being moved, but that's it. Simultaneous to these two cases severely limiting federal power over the economy, the president's power itself is severely limited. And in Humphrey's Executor versus the United States, this Supreme Court said the president cannot fire people who work for the administration without some sort of congressional approval. So Congress's power over the economy is now gone. The president's power to have whomever he would like work for him is gone. And you can imagine FDR is not incredibly happy. So he gives this fireside chat. And his plan is that for every Supreme Court justice over the age of 70, who has at least 10 years of service on the court, I get a new nomination. He was losing every case 5-4. The number of justices who met his criteria was 5. The assumption would be he would put 5 on. He would now win all of the cases that he was losing 5-4 because he would now, actually it was 6. So it would be a total of 15. He would now win all of the cases 10-5. That's if all of his new appointees would actually follow what he wanted them to do, which we know doesn't always happen. Everybody, as I said earlier, was up in arms about this. The press, public opinion polls were wildly against FDR, and in fact, members of his own party in Congress did not like this plan. And he was saved by Owen Roberts when in West Coast Hotel versus Parrish, Roberts made, and you have heard this phrase, I know you have, this switch in time that saved 9. Roberts flipped his vote, ruled with the other 4, upheld a regulation in Parrish, and the floodgates opened. And FDR didn't need to pack the court, did not need to pack the federal judiciary, and he moved on with his life. And so the court was in some sense beaten, and that might cut against my argument, but for that time until that date, the court very powerfully beat back every single thing that FDR wanted to do. And then we get a new era. Because if you get a new era, you might assume the court did lose, and the court wasn't powerful. But that is not what happened, because between 1937 and 1943, FDR fundamentally changed the United States Supreme Court. He ultimately had 9 appointments. He put 9 justices on the bench. Most of them, and I say this lovingly, were his New Deal cronies. So he puts Hugo Black on the bench in 37, Stanley Reed in 1938, Bill Douglas in 1939, Felix Frankfurter, who by the way was accused for a large part of his life of being a socialist, in 1939, Frank Murphy in 1940, Harlan Stone in 1941, James Burns in 1941, although he actually left in 1942, Robert Jackson in 1941, he of Nuremberg fame, and Wiley Rutledge in 1943. As an aside, right, you think 9 is a lot. George Washington had the most appointments in history with 14. 12 of them were confirmed. And John Tyler, of all people, John Tyler, one of the middle 19th century presidents who we don't talk a lot about, also got 9 appointments to the United States Supreme Court. So he tied FDR for second most in history. And this completely remade court was probably even more powerful than the pre-1937 court. And the transformation is complete, and the jurisprudence of the United States Supreme Court takes a decidedly turn in 2 ways. One is it becomes incredibly liberal, right? Think about those names that I laid out, Black and Douglas and Jackson and Frankfurter, who ends up being more conservative towards the end of his tenure. But as I said, New Deal cronies, these were liberal, quite liberal-leaning folks to be on the United States Supreme Court. So it takes a turn left ideologically, but it also takes a turn in its agenda. Prior to the end of the New Deal era, in the early 40s. The court was deciding largely economics cases because we were still, right, the Industrial Revolution is over. We're post-Industrial Revolution, but the court is dealing almost exclusively with three matters: economics cases, federal power cases, state power cases. That's about it. The court decided, and I just finished teaching my civil liberties class this term, the court decided no more than a handful of cases dealing with the Bill of Rights in the 19th century, and only a few in the 1920s. It wasn't until the 1940s that the court fundamentally changed its agenda and started looking at civil liberties in the First through the Eighth Amendments. And it was this court, with the complete revamping of FDR in FDR's image, that the court began to do things like increases free speech protections, well, First Amendment protections generally. So in 1940, in Thornhill versus Alabama, the court finds that you actually have the right as a union or as any group to picket. Prior to that time, picketing was not a protected right. In Cantwell versus Connecticut the same year, the court institutionalizes and actually incorporates to the states the freedom of religion. And in West Virginia versus Barnett in 1943, the court says you have the right not to speak, meaning you do not, or you have the right to not have to say the Pledge of Allegiance in school. It increases federal power over commerce. It overtakes and overturns these decisions I talked about, Carter Coal and Schechter Poultry. And in U.S. Darby in 1940 and Wickard and Filburn in 1941, the court says there is now absolute control over commerce. To the point in Wickard versus Filburn, Congress has the power to actually, and to this day, Wickard is still good law, to tell you what you may or may not plant in your gardens at home. Okay? In that case, the family was growing wheat. It was abiding by the federal regulations on what its quota would be of growing wheat. But then it decided to keep some back for the family so it could make its own bread and feed their children. And the federal government found out and told them you can't do that anymore. And the Supreme Court upheld that regulation. I've had students in my class on Commerce Clause stand up yelling at me, libertarians who say, you gotta be kidding me, I can't plant carrots in my own garden. You can't if the federal government tells you you can, and it was this court that increased that power to that extent in 1941. Massive increase of power for the federal government during times of crisis. Right, one of the biggest black eyes on the United States Supreme Court's entire history, Korematsu versus the United States in 1944, but also its previous year decision in Hirabayashi versus the United States. Korematsu, the more difficult of those cases, it says it was perfectly okay for the president to take people who we believed were of Japanese descent, even if they were U.S. citizens, and even if they were probably of Chinese, Korean, maybe Laotian descent. We didn't know because we all thought they looked the same, apparently, and moved them to the middle of the United States so that they could not cause problems during World War II after the bombing of Pearl Harbor. An increase like we'd have never thought would happen for federal government power. And then this court increases the federal government's power over race relations in the United States. In Shelley versus Kramer in 1948, the court bans restrictive covenants. In Sweat versus Painter in 1950, it forces the University of Texas Law School, through a really interesting decision, to allow African American students into that law school to learn the law with their fellow white students. And when Chief Justice Vinson died in September of 1953, the transformation to the liberal court was essentially, but a little bit ironically, complete when President Eisenhower nominates Earl Warren to be the Chief Justice of the United States. And we turn to the Warren Court from 53 to 69. Now, why would it be ironic? Ike was asked after his 8 years in office, did you make any mistakes? And he said, 2. And they're both on the United States Supreme Court. He had nominated Earl Warren, who was a good Republican governor of California, and William Brennan, who was a very good Republican Party leader in New Jersey. And both of them combined became two of the 5 most liberal justices ever to sit on the United States Supreme Court. So it wasn't FDR or Truman who made the transformation complete. It was ultimately a Republican president who had done so. And so what do we get on this court? We've got Douglas and Black, who are the last justices from the FDR nominations. And then Eisenhower puts on 4. The 2 I talked about, Warren and Brennan. And then puts on 2 moderate-leaning conservatives in John Harlan and Potter Stewart. JFK puts Byron White on the bench. If you're big NFL fans, you may know that he was also a star NFL player before joining the United States Supreme Court. And then LBJ puts on 2 of the other 5 most liberal justices ever to sit on the bench, and Thurgood Marshall and Abe Fortas. The former we named one of our sons after. Although my wife would not let us call him Thurgood, she thought it wouldn't be good for him on the playground, so his middle name happens to be Marshall. He kind of likes the middle name, I think. What does the Warren Court do? What are these guys who are now and still to this day considered the most liberal court in the history of the United States Supreme Court? What do they do beyond what the early FDR court had done? Well, they continue with race relations and civil liberties. They make the Brown decision in 1954 and then Brown II in 1957 that says we are going to integrate schools. And even though they pull a punch and use that phrase with all deliberate speed, they still say at this point in history, separate but equal is not good for the education of any kid. We're going to integrate schools and do it as quickly as we can. It decided in 1958 a lesser-known case, Aaron versus Cooper, that says all states must follow Supreme Court decisions. And why would the court take a case just to make that proclamation? It's because so many states, most south of the Mason-Dixon, were simply ignoring Brown. So Aaron versus Cooper says, you will listen to us, and you will listen to us now. Although it wasn't until 1969, at the advent of the Warren Burger Court, that we really move much closer to full integration. The court focuses, in particular during the Warren era, on criminal defendants' rights. So in 1961, it decides Mapp versus Ohio, which gives you the right to remain silent, and forces the police to read you rights that tell you you've got the right to remain silent before they can question you. Tries to protect accused criminals from being browbeaten into coerced confessions. As an aside, in Mapp versus Ohio, if you were boxing fans in the 70s or 80s, Don King, who was the literal Don of the boxing world, was involved in Mapp versus Ohio only because it was his house that had been firebombed in Ohio. And it was in Ms. Mapp's house that they were looking for the alleged firebomber of Don King's house. The court increases Sixth Amendment rights in Gideon versus Wainwright in 1963 that says everyone now, no matter how small a case, even in traffic court, you have the right to be represented by an attorney. If you cannot afford one, the state will absolutely pay for that to happen. And then the court decides in 66, Miranda versus Arizona, and I apologize, I misspoke on Mapp. Mapp is searches and seizures. I apologize, I misspoke. Miranda is the right to remain silent. Not sure why I messed that up. I've been teaching those cases for 30 years. The court increases First Amendment rights again, both in the religion area as well as in the speech area. In Engel versus Vitale in 1962, the court says no more prayers in public schools can be read. In Schempp in 1963, not only can you no longer read prayers in schools, you're not reading Bible verses to kids in public schools anymore. That is a violation of the separation of church and state. And then in 1969, the ultimate case in free speech law, which is still good law today, Brandenburg versus Ohio, the court says the only time government may regulate your speech is if it creates what is known as not a clear and present danger. That's actually Schenck from 1920. Only if that speech is going to cause imminent lawless action. Now, this is an ironic decision as well, because that case was not protecting civil rights protesters. Brandenburg was protecting the KKK's right to march through Columbus, Ohio. So you take the Warren Court and says, we don't care what ideology you're espousing, we will protect your right to say what you would like to say. And then finally, the one that is probably the most controversial because it was created, in some sense, just like judicial review out of whole cloth, and that's the right to privacy in Griswold versus Connecticut, which astounded my students last Thursday when we talked about Griswold. And the idea that you actually did not, as a married couple, have the right to use contraceptives in the privacy of your own bedroom. And it was Griswold where the court said, we can find the right to privacy. Even though the Constitution and the Bill of Rights don't use that word, we can find it in the First and the Third and the Fourth and the Fifth and the 14th and ultimately the Ninth Amendment to the Constitution of the United States. And if you have questions about that, I'll talk about that. But Griswold, which every single justice on the court knew that by deciding Griswold, they were deciding Roe versus Wade. They didn't know Roe existed yet in 1965. But if you look at the archival papers of the justices, they knew that the ultimate conclusion of granting a right to privacy was actually going to lead them to a woman's right to choose abortion on demand, which is obviously in question and up for grabs right now in Dobbs versus Mississippi, that the court will decide in about 2 months. And I'll finish and then turn to Q&A by talking about the current court. And let me talk about the first two iterations of the Roberts Court from 2005 to 2016. And this is how the Roberts Court looked when he took over in 2005. We still had John Stevens and David Souter and Anthony Kennedy on the bench, and Justice Antonin Scalia. And that changed right in the Obama era, where we gained Justices Sotomayor and Kagan and lost Justices Souter and Stevens. And then it changed again after the death of Justice Scalia. But from 2005 to 2016, the court actually showed its power as well. And I'll just lay out a few of the cases that it dealt with. One that you might not have expected to come from the Roberts Court. It protected the right to same-sex marriage. Now again, that right may be in question again with the current iteration of the Roberts Court, but not this term and presumably not next term as well. But in Obergefell in 2015, the court says the Due Process Clause and the Equal Protection Clause say that you have the absolute right. It's a fundamental right to choose who you'd like to marry, and that can be someone of the same gender. But all of the other big-time cases during this era of the Roberts Court are what you would expect in terms of ideological side that they come down on. So it ingrains the individual right to bear arms in Heller, District of Columbia versus Heller, and then incorporates that right to the states in McDonald versus Chicago in 2010. It applies free speech to corporations and to unions in Citizens United. And that, in some sense, there is a school of thought that suggests that that is a liberal decision because it expands the freedom of speech. Others would argue probably not so liberal because it expands the freedom of speech to entities that are not individual. And if you buy the argument that the First Amendment and the Second Amendment, in fact the entire Bill of Rights, are aimed at individuals, then giving those rights to corporations and unions might be problematic. But in the end, this court expands that right in a really, really massive way. And then finally, it expands freedom of religion to this term, closely held corporations. And apparently I cut and pasted "and unions" in there as well. In Hobby Lobby in 2014, which I'm sure many of you have heard of, the court delivers an opinion that exempts these type of corporations from Obamacare or the Affordable Care Act's contraception mandate. It says if you are this sort of small company and your beliefs say that your insurance plan should not control contraceptives, then you do not need to cover them. One would argue that that could also be seen as a liberal decision because it's an expansion of freedom of religion for the corporation or the people who own that corporation. On the other hand, it is a denial of equal protection rights in some sense and due process rights, because the women who might need that contraception and can't afford it but for the insurance plan are now no longer going to be able to obtain it, or at least obtain it easily. So some powerful decisions handed down by the original iterations of the Roberts Court. And now we get to the current era. And the current era still includes Justice Breyer because he is not done until the end of June. It's a slightly different picture because I could not find a picture like the other ones that laid out the justices in order of ideology. But you will note with clarity that the blue justices are Democratic appointees and the red justices are Republican appointees. In terms of who appointed these justices, the most senior associate justice on the bench, Clarence Thomas, is a Bush 41 appointee. The Chief Justice and Justice Alito are Bush 43 appointees. Justices Gorsuch, Kavanaugh, and Barrett are Trump appointees. The last Clinton-era appointee will be gone in 2 months, and that is Stephen Breyer. And then Justices Sotomayor and Kagan are President Obama's nominees to the bench. And what has this court done, and how does it continue to be powerful? The potential changes that we could see at the end of this term and as we move into next term. Either massive new restrictions on the right to obtain abortion on demand, or a complete overturn of Casey and or Roe, both of them. The one thing to note about Dobbs versus Jackson's Women's Health is that this case was a classic bait and switch. And I mean that as a scholar, not as someone who's making an ideological argument. Litigants do this on a regular basis. They will present a case to the court that is one question. In this case, the question in Dobbs was supposed to be a 15-week ban on abortion. No abortions after the 15th week of pregnancy. And after the court accepted that case onto its docket, in a reply brief, the state of Mississippi said, no, the question is really, should you overturn Roe versus Wade? Normally, the court will say, we're not going to deal with that nonsense, but the litigant in this case knew that it had a friendly court. So the justices accepted the friendly amendment to the change in the focus of that particular case. There's going to be an increase in Second Amendment rights. In New York State Rifle and Pistol Association versus Bruin, the court is dealing with the issue of a New York law that challenges anyone who wishes to carry a handgun in public needing to demonstrate, quote unquote, proper cause to do so. And there's every reason to believe that with Heller and McDonald being the key precedent, given the ideological leaning of the court, that in fact now anyone in New York, and then once the decision is handed down nationally, will be able to carry a weapon and not necessarily need it to be concealed. And that will be a massive expansion. Again, you can debate whether you think that is a liberal or conservative decision. The court is probably going to rescind the Chevron Doctrine. Now, you might say, I'm going to yawn about this one after you've just talked about reproductive rights and gun rights. But the Chevron Doctrine is incredibly important because the Chevron Doctrine says this: when an executive administrative agency makes a ruling, if there is a lawsuit about the decision that's been made, courts will defer to the expertise of the administrative agency. Now, that's given lifetime bureaucrats massive amounts of power, and they are not elected or reelected. Like judges, they don't have a constituency to whom they need to kowtow to get votes to get back into office. This court, this term, in its EPA case, may very well scuttle the Chevron Doctrine and say we will no longer defer to bureaucrats. We, the U.S. Supreme Court, as well as lower federal courts, will be the ultimate arbiter of administrative agency decisions. The court's taking a rightward turn in religion cases. It is continuing to decide that Establishment Clause cases, that is separation of church and state cases, are not separation of church and state cases. They are actually freedom of religion cases. And so the court is using the freedom of religion clause of the First Amendment to actually bring the state, usually in the form of schools, usually in the form of things like vouchers to send kids to private religious schools, closer and closer together. And the liberal view of separation of church and state is that they should be widely separated, or there should be a high wall of separation between the two, whichever analogy you would like to use. But the court is taking a rightward turn in that case. It is probably going to end up ruling in favor of what is known as, or who is known as, the praying football coach, and allow prayers to be said in public schools among whether it's football teams or debate teams, or prior to band concerts, or prior to musicals that are put on stage, and those are markedly rightward turns ideologically. Next term, before I wrap up and talk about what these courts have in common, next term the court's probably going to take a rightward turn on affirmative action. It has a Harvard case where it will probably really cut even more strongly against the grain of protecting minority groups at ability to get into colleges and universities. It is going to reconsider the Masterpiece Cake Shop decision, where cake maker did not want to make a cake for a same-sex couple that was going to get married. This case now deals with a photographer who would not like to do so. Masterpiece Cake was thrown out several terms ago for technical reasons, or decided in technical reasons. This court probably will decide the case straight up on free speech and freedom of religion cases. And then finally, and probably most importantly, the court will take up next term another Voting Rights Act case, specifically majority-minority voting districts in Alabama. And there's every reason to believe, given what has gone on with the shadow docket and voting rights this past term in particular, that the court is going to continue to cut back at the Voting Rights Act, as well as several provisions maybe of the Civil Rights Act of '65 as well. So that's a bunch of courts. What do they have in common? What makes them so powerful? Very strong ideological majorities, right? Marshall, strong majority of Federalists. Prior to 1937, strong majority of hardcore conservatives on that pre-New Deal court. Afterwards, strong majority of liberal justices. The same with the Warren Court. Massive liberal majority on that bench, and now today the same with the Warren Court. And there are other examples, but I just don't believe they were as powerful. The Taney Court, beginning in 1936, had a very strong states' rights coalition on it. The late 1800s and early 1900s, an incredibly strong, economically conservative Supreme Court, and some would argue that the Rehnquist Court was quite strong as well. They decide large numbers of salient cases as well, ones that the public cares about and that divide us or polarize us along party lines and ideological lines, and then they stay together for very long periods of time. And this court, I say this to my students and their eyes get wide, when my 20-year-old students today are our age, 60s and 70s, there are justices on this court that will still be on the court when those students are in their 60s and possibly close to 70. And then finally, these are activist courts. The Warren Court got a rap for being an activist court, and we assumed that only liberal courts are activist. Not true. Conservative courts can be just as activist. They invoke judicial review on a regular basis, and they do so very effectively. So in the end, who's right? It was John Marshall. We don't have a musical about Marshall. We do have one about Hamilton. But Marshall wins the battle of whether or not the court is strong or weak, because in fact it shows again and again and again that it can and is stronger than Congress and stronger than the president. And in fact, the court has always been that powerful. Two last points. There is no more center on the court. Right? The great secret of the Warren Court was that it was the center, the Potter Stewarts and the John Harlans and the Harry Blackmans and the Byron Whites, that drove a lot of the decisions of that court. It had sometimes a majority of liberals, but not always. It needed to drag along the center. And that doesn't exist anymore, especially when you note that today the median justice, the middle justice on this Supreme Court, is Justice Brett Kavanaugh. And that means that the court has taken a decided turn to the right. And finally, this court is going to remain highly conservative, it's going to remain highly activist, and it is going to exist for a very long period of time. That is, unless either President Biden or Vice President Harris or whomever the Democrats choose in 2024 wins, and if the Democrats can continue to hold the Senate. That's the only way this current court changes shape and changes direction. Thank you for your time. I will take any and all questions. I appreciate you coming out tonight.
Well, we have quite a number of questions. So
Oh, good.
with such enormous swings in direction, what is the value? Is there any value of judicial precedent?
Yeah, this is a really, really good question because the court historically really believes in precedent, right? This is the grounding that we know as citizens that we think makes the court legitimate. And so when you read the court's decision in Planned Parenthood versus Casey, which was a compromise between three moderate right-leaning conservatives in Justices Kennedy, O'Connor, and Souter, and the opening paragraphs of Planned Parenthood versus Casey 30 years ago now says precedent is everything. And we're going to preserve precedent at all costs. Even if we're going to say we're going to change the rule on how we determine when a woman has the right to choose abortion on demand from this odd trimester scheme created in Roe versus Wade to now this legal standard called the undue burden standard, the idea in Roe, the precedent from Roe stays the same, and that is that a woman at a large part, at least early on in her pregnancy, has a right to choose an abortion. And the court says this again and again and again. The better and less controversial example is one of my favorite stories about former Chief Justice Rehnquist. And those of you who have seen me speak before will know this, and my wife knows it as well. I can't answer any questions simply or quickly, and there's no yes or no questions or answers from me. My favorite example is Rehnquist. And one of the keys to Rehnquist getting on the bench in 1970, he had made it his mission in life to overturn Miranda. He thought that the idea of having to read someone his or her rights before you could question them was anathema to the police because it completely stopped the police from having power to get a confession. So Rehnquist looked for years. He even becomes chief starting in the 86th term, looking for years for a case to overturn Miranda. And in the early 2000s, and I'm bad with dates, it's either 03 or 04, he gets that case. Dickerson, of all places, versus Minnesota. And we're going to overturn Miranda. Rehnquist gives the opinion to himself to write. And he writes the opinion, and it's going to be handed down, and everybody and their brother is freaking out because Miranda rights are gone, and the criminally accused are screwed. And the opinion by Rehnquist says, can't overturn Miranda. Miranda is so ingrained in our psyche, so ingrained in our criminal justice system, that how could you get rid of that precedent? Think about it. I say to my students, Law and Order is now on 24/7. You can find it on any channel or any streaming service. We all know by heart you have the right to remain silent. You have a right to an attorney. If you can't afford one will be provided for you. And Rehnquist says, and suddenly we're going to tell the criminally accused that they no longer have those rights? That's a problem. And on top of that, Rehnquist figured out something that he didn't expect to figure out. Miranda warnings don't just protect the accused, they actually protect the cops. Because once you've read people those rights, you still can't beat them up to get a confession, but you can do anything you want. You can lie to the criminally accused to try to get a confession, but only after they understand that they have those rights. So precedent is everything. So does it mean nothing anymore because we get these wild shifts? No, it still means something. It's still, the justices still try. Now, last point, and then I'll move to the next question. The court reaffirmed today in a highly controversial decision the idea that citizens of Puerto Rico do not get SSI benefits if you are blind or disabled and over the age of 65. That's been a law passed by Congress. I don't remember the exact year, but it had been reaffirmed by the Supreme Court several times. Justice Gorsuch was actually part of the majority that agreed with that. but he wrote a scathing, you should go read it, a scathing concurrence that said those precedents that exist that told the majority that it's got to do this, we need to go overturn those precedents because they're really bad. Unfortunately, none of the litigants in the current case had asked them to overturn those precedents. So the majority decided not to deal with that issue. Gorsuch was angry, and I've seen him write a couple of pretty angry concurrences and dissents. This might have been his angriest. Precedent is important and will continue to be no matter what, unless we start seeing wild swings from term to term to term to term. And we're probably not going to see that. Sorry for the long answer.
When it combines to, because I think you can probably address them together. So do you think the current court appears more political, illegitimate than previous courts, and has Chief Justice Roberts lost control of the court?
Yeah, so I think the answer to the first one is absolutely yes. And the reason for that is what has gone on, not in the court itself, but outside the court. And specifically with confirmation hearings and with the politics that were played, right? The idea that after Justice Scalia's death, that President Obama did not get a shot to nominate someone. And all the Republicans had to do in the Senate was say, yeah, bring it on. Let's have the hearings. Let's do everything on the up and up, and then we just vote no. But instead, it was politicized. Now, this isn't to blame the Republicans, because the Democrats politicize things just as fine on their own. But that politicization of what happened with the Merrick Garland non-nomination, and then turning around and actively claiming that you forgot that argument in order to allow Justice Coney Barrett to get on the bench 2 weeks prior to the election in 2020 is really problematic. But I say this to everybody and anyone who asks about Senate politics. We all live in the era of two of the greatest politicians in the history of our government. One is Mitch McConnell, love him or hate him, because he's beaten the Democrats at every term, and the other is Nancy Pelosi, because she's beaten the Republicans in the House at every turn. Now again, you might love one and hate the other, but they are both brilliant. And in fact, I could use the technical term freaking brilliant at what they do, and McConnell has beaten it. But what he's done in beating the Democrats in the Senate is he's politicized the court in such a way that has made it much worse than the Rehnquist court seemed very political. The Warren court seemed pretty liberal or pretty political. Part of the Berger court seemed highly political and controversial. It all pales in comparison to what the elected branches have made the court look like today. And as to the second question, Roberts has lost all control. This is no longer the Roberts court, it is the Clarence Thomas court. And think about it in terms of the Dobbs case. The Dobbs case very well could be 5-4 and Roberts will be in dissent, and here's why. The rule on the court, the norm on the court is if the Chief Justice is in the majority, he picks who writes the majority opinion. Okay? So imagine that it is a 6-3 decision. Roberts assigns the majority opinion to himself to write a very narrow majority that says, we're not going to overturn Roe versus Wade. That precedent's too important, but we're going to severely restrict. We're going to actually allow the 15-week ban. Well, all the other 5 have to do is say, nope, we're not going to sign that. So imagine then Thomas says, I'll just write the opinion. Chief, I'll do it. And my opinion says never again is there going to be an abortion performed in the United States. The chief can't stop him. Period. End of story. It is the Thomas court. And Roberts is going to go down in history as, sadly for him, a very impotent Chief Justice, whereas he was very powerful and made some interesting decisions. Think about the Obamacare case in 2012. He has none of that power anymore.
Well, bringing up Justice Clarence Thomas brings us to another question. Should Justice Thomas recuse himself if the January 6th cases, on the January 6th cases in light of his wife's comments and involvement?
So the short answer is yes, because when there is involvement that closely by a member of your family, recusal is the proper remedy. Unfortunately, all of the canons of judicial ethics that apply to every other federal court, the 94 U.S. district courts and the 13 circuit courts of appeals, have never applied to the United States Supreme Court. When it comes to recusal, the only person, and I mean that in terms of a singular, not a plural, the only person who decides whether there is a conflict of interest that is big enough to force you to recuse is the justice who is deciding whether to recuse. Okay, so let me use Justice Scalia as an example. He did not recuse himself from the Sierra Club lawsuit against Vice President Dick Cheney, even though he had been duck hunting with Cheney just a couple of months before the case was orally argued. He said, I can duck hunt, I can make decisions, even if it involves the same guy, I can be objective. People were up in arms about that. He did decide, and he voted in favor of the vice president. But when the court heard the Pledge of Allegiance case in the early 2000s, I think it was the Pledge of Allegiance case, I could be wrong, it was a religious freedom case. Scalia had given a talk that summer about that case and about religious freedom in particular, and realized that he had stepped over the line, and he recused himself from that case. Other cases he wouldn't recuse himself from. He had two sons who were lawyers and still are lawyers in D.C. He wouldn't recuse just because their firm came. He may have recused if one of his sons had been the arguing attorney, which I don't think ever happened. Ginsburg would recuse in any case where her husband, because he owned the law firm, where his law firm would come. But in the end, it is the justice's decision and his or hers alone, period. Should he recuse on a January 6th case? Yes. I think that the closeness, the conflict of interest is too close. Will he? I will bet anybody in this room any amount of money that you want to put up, and I get to take the he will not recuse side. And that's just a fact.
Given the long-standing right to privacy and its basis in so many amendments, how do you anticipate the current court will address this right if it does overturn Roe v. Wade? And then are there any implications going along with that for the Second Amendment cases?
Yeah, so here's what the court's going to say. And again, God, this is being recorded. I don't like making public predictions, but I cannot. But you can imagine what the court's going to say, right? The majority right now is governed by textualists, and all that means is they read the literal meaning of the text. So, for example, this is one of the reasons why Hugo Black would protect something like someone's right to say whatever swear word they wanted to in this hallowed hall of the City Council of Edina. You can say any swear word you want, but he wouldn't probably allow someone to walk through here and raise their middle finger, because one, he would consider speech because it came out of someone's mouth, and the other would be considered symbolic, and Hugo Black was very clear on that, and that's the problem you get with a textualist. But bring textualists back to privacy. They have an easier row to hoe than did Black to dance to make that argument. A textualist in privacy just has to say, read the text. There's no word privacy. It's not in Article 1, 2, 3, 4, 5, 6. It's not in Amendments 1 through 27. I dare you to find the word privacy with a Control F search when you've got the Constitution up in a Google search. It's not there. So you can insinuate all you want that the freedom of association, the liberty to not house and to not quarter soldiers, that you've got the liberty against illegal searches and seizures, that you've got due process in the Fifth Amendment, that you've got equal protection in the 14th Amendment, and then you have this nebulous Ninth Amendment that nobody ever talks about. Right? We talk about the controversy of the 10th Amendment, but the 9th Amendment says, and I won't quote it verbatim because I can't, and that is, just because we gave you these other 8 liberties doesn't mean you don't have others, which is actually probably the best place where you'd find privacy. But the textualists will simply say it's not there, and it's not in the 9th Amendment either, so it goes away. So the implication is the right to privacy could very well, that's the real problem, right? I mean, it's problematic for half the population to say that you cannot obtain abortion on demand anymore. That's problematic in and of itself. But if the court goes down that path that says you can't find the right to privacy anywhere in the Constitution, Can you still use contraceptives? Maybe a state says you can't. Can same-sex couples engage in sex in the privacy of their own bedroom? Maybe 2 years from now they can't. And so that's sort of the down-the-road implications of making the argument that there's no longer a right to privacy. And I'm not making any normative statement about whether that's good or bad. You can decide that for yourselves. But those are the implications of what could happen if that is how that case is interpreted. And I'm not exactly sure how to apply that to the Second Amendment. I mean, this court is just a very friendly Second Amendment court, period, end of story. I mean, it simply really believes that no matter how you read the Second Amendment grammatically, it really does insinuate an individual right to carry arms. And the court's going to then have to decide for itself whether that means, I don't know anything about guns, so I'm just going to throw out words, and if I'm wrong, you can correct me. A Glock is a sidearm, right? Or I don't know if Smith & Wesson makes long guns, right, for deer hunting. Can you carry that down the street? Can you carry an AR-15? Can you carry a bazooka? Can you carry a grenade launcher? The court's going to have to deal with all of those issues as they continue to say there's a stronger and stronger right to bear arms.
Is there any chance Citizens United may be overturned?
I would say that if Justice Kennedy was still on the bench, let's actually say that it is that second manifestation of the 05 to 2016 court where Kennedy is sitting in the middle. And knowing what they know today and knowing what they know has happened monetarily in elections, I think there's a chance. Today, no chance at all. That'll be my shortest answer of the night. It will not be overturned. In fact, it may be strengthened.
Okay. How about this one? Do you think the court would address the praying football case any differently if the praying football coach was leading Muslim prayers?
Oh, that's a phenomenal question. In fact, I would say no. And here's the reason. The justices fundamentally know that if they start demarcating which religions are protected and which are not, that's bad for the religion that they believe in, right? And we know that there are only two religions represented on the court right now, and and there won't be after Breyer is gone. Right now, there's one person of justice of Jewish descent. Everybody else is either Catholic or Anglican, I think. Oh no, because Kagan will still be there. So there's two folks of Jewish descent on the bench. I don't think they would. And I'll give you an example to show that this is the case. The justices, as well as elected officials in the United States, know that in order to have protection for what they believe in, right, when they go to church or synagogue or mosque, although we haven't had a Muslim on the bench, you actually have to protect everyone. And the court has been really pretty good at saying we protect everybody's religious freedom. Now, early on in the 20th century, there were some religions that they would not protect. So, for instance, they would protect your beliefs in Mormonism, but they would not protect your ability to be a polygamist. And the court has said, since it began trying to define religion, it has always said that at a minimum, the religions that get protected are those that existed at the founding. And you can name them, right? Judaism, Christianity, Islam, Buddhism, Shintoism. I mean, I'm not going to go on beyond that, but the reason Mormonism and Seventh-day Adventists and Jehovah's Witnesses didn't get protection early on is that the court said, well, you didn't exist. You weren't part of our traditions in 1776 and in 1780 and in 1791. So we don't protect you. But I do think that in the end, the bottom line is yes, because in protecting a Muslim football coach, you protect all football coaches to bring religion back into public schools.
Okay. How can a lower court judge in Florida reverse a federal mask mandate for the entire country?
I mean, this is the exact same way that a federal district trial court judge tells President Trump that he couldn't have a ban on people coming in from Muslim countries in the United States. Trial court judges can have actually pretty strong power from time to time. The problem is that we don't see that happen on a regular basis. Trial court judges don't generally issue opinions, they just issue rulings in trials, but sometimes when it's a case this big, you will get a judge who says, in this case she says, no, I'm going to actually write an opinion that talks about this policy. Unfortunately for this judge, it is probably decently clear that she misinterpreted the word sanitation, in the statute that she was referring to that said the CDC can no longer force masks to be worn on mass transportation. The other implication of this case, to take it one step further, in terms of the policy power that trial court judges can have at the federal level, is that if her decision is actually upheld by the circuit court and then ultimately upheld by the United States Supreme Court, the CDC ends up being powerless to probably stop any new pandemic. And even though, and I think it's the 11th Circuit that the case is being appealed to, and it's a pretty conservative circuit, my guess is that court is going to see that this is much more than a case about masks. It's going to see that this is a case about federal power. And while we've got the Chevron Doctrine issue going on that I talked about earlier, I gotta assume there's a pretty good probability that her decision gets overturned. Now, does that mean the mask mandate will go back on planes, trains, and Ubers? Probably not. But the Biden administration has no choice but to appeal, because if it doesn't, then the CDC really is impotent.
This question goes back to when you were talking about the Hobby Lobby case, where you talked about that it expanded the freedom of religion to closely held corporations.
Right.
So the question is, why wasn't the Hobby Lobby case considered a blurring of separation of church and state?
Right. That's a really good question, because Hobby Lobby is not the government. Right? The separation of church and state is between a governmental entity and a religious organization. Hobby Lobby is not. Now, I can understand maybe where the question is coming from, and that is that the blurring is that Hobby Lobby gets some more freedom because it gets to get out of this governmental regulation. But it's really the exact opposite. This is just a private party that wants its religious freedom upheld, and it has really nothing to do with government involvement, because it's an individual versus an individual.
And I think this question is hearkening back to you talking about how voting rights cases and civil rights cases, a lot of that legislation might be gutted or severely limited. So the question is, what's there to look forward to for us human and civil rights activists?
Well, I mean, look, here's the way that things change, right? I don't generally give policy advice, and I don't to my students in the classroom either, but the way that things change is to change your elected officials. Right? So you make sure that you get a Senate and a president who will give you nominees and confirm those nominees who believe in the things that you believe in as a civil rights activist. Right? We are at just as I think pretty conservative people thought they were in a dark age of the law during the Warren Court, and especially the late Warren Court, like 64, 65, all the way through 69. That's what liberals are feeling today. And the only way you change that is to change the elected officials, because that's how you get judges into power. Now, unfortunately for the Democratic Party, they've been really unlucky. Right? Nixon gets 4 appointees, Carter got zippo, and not for lack of trying. The Carter administration begged, borrowed, and stole to try to get Thurgood Marshall to resign, and he didn't. And that was a disaster, right? Because he was replaced by Bush 41 in 1991. But then Reagan ends up getting a slew of nominees. Bush gets Souter and Thomas. Now, Souter turned out okay for the left. Right? He was obviously a stealth candidate and much more liberal than people thought. Clinton gets 2, but then Bush gets 2, and then Obama gets 2, and then Trump gets 3. I mean, the Democrats have just been they've been out-counted, if you will, and the only way to mitigate that is through the elected branches. I mean, Mitch McConnell should have been beaten. And if he's beaten, then the Democrats have a much easier road to hoe. But he wasn't.
Well, then this is fitting that this is our last question, unless there are any more from the audience. What can be done to reduce the possibility of court packing?
I mean, it's not going to happen. That's it, right? So we're not going to reduce the possibility. The one thing that reduces the possibility is what already happened, and that is that the Biden administration didn't pack the court. I will give you my spiel on this. I'll get on my soapbox for just a second. And I actually do think the Biden administration should have done not court packing, but court correction. So you could call it maybe court packing light. And I will say this because I think it's probably what should have been done. Prior to the Garland and Coney Barrett nominations and confirmations, the court was split 4-4 with the chief in the middle. And the chief, right, he spent some political capital by deciding the way he did in dissenting in Obergefell, but then he gains a lot of political capital by saving Obamacare, right? And he sort of went to try to protect the institution and was deciding some with the liberals and some with the conservatives. I would say that Biden should have said, we're going to go not to 13 or 15 or 17 or 19, but we're going to go to 11. And we actually fundamentally believe that the Republicans court packed by what they did with the Merrick Garland non-nomination and with the Coney Barrett nomination and confirmation. So let's get those 2 back. Let's get 11 on the court, and now you have 5 and 5 and 1, and we're back to ground zero. Right, or put to point A. And while the Republicans would have been upset about that, and it would have been a slew of news cycles of screaming and hollering like the Democrats did when those 2 nominations happened the way that they did, it would have died down. And I don't think you would have gotten a tit for tat that many legal commentators think that we would have gotten. And that is, once you'd get a Republican back in the White House and the Republicans controlling the Senate, that they would now put 2 or 3 or 4 more on. I really don't think that that would have happened. We're going to do this in this one instance and go back to normal, I think might have made everything better. But given that Biden never moved on court packing at all, no one's going to move on court packing. That's my best guess.
I think we have no other questions, so I would just like to thank you very much for your presentation. That was excellent, and the questions from the audience. And thank you all for coming. I hope you picked up some things, and feel free to tell your friends, if you think they'd be interested, that this will be on the League of Women Voters website, LWVeedina.org, in the next day or so. I don't know exactly when, but we are going to put it on the website so they can hear some of the wonderful information as well. And thank you very much. Thank you so much. It was great.